Breaking news right now, President Trump and his legal team are looking to get his historic Manhattan hush money conviction thrown out. So it took a 96-page filing to make that argument, and CBS News got it. It shows that Team Trump wants that conviction dismissed because of a Supreme Court ruling on presidential immunity. They are even calling out the judge who presided over that case for not recusing himself because of a prior donation he made to the Democratic Party.
Hello and welcome to Prime Signal. There is a signal flashing across the American court system right now that should freeze Donald Trump solid. Not a warning, not a prediction, a signal.
So the president was convicted back in May last year on 34 counts of falsifying business records to cover up payments made to adult film star Stormy Daniels. The president's attorney calls the charges unprecedented and says his team will continue to keep defeating Democrat weaponization at every turn. That is their chosen word. So let's bring in CBS News Justice reporter Jake Rosen, who's watching this filing. Walk us through Team Trump's arguments.
Well, Reed, if those arguments that you just laid out, that the judge, Juan Merchan, who oversaw this case in Manhattan state and local court there, and that there was some kind of immunity given to President Trump.
One by one, federal and state judges are doing something that seemed impossible just months ago.
President Trump wants a New York State appeals court to toss out his hush money criminal conviction. In a court filing late last night, his lawyers argued there was no intent to commit a crime and the evidence was not sufficient to convict. The Manhattan District Attorney's Office prosecuted the case and will have a chance to respond in court. We did reach out to them and they declined to comment. In May of last year, Trump was convicted of 34 felony counts of falsifying business records to conceal a hush money payment to an adult film star over an alleged affair.
They are taking the legal shields Trump spent years constructing the arguments about immunity, about executive supremacy, about the presidency placing a man above accountability.
Kim, they've tried to move this case to federal court before, but were not successful. So what's different this time?
Well, this is now on appeal to the Second Circuit. So the district court judge, the federal judge said, no, you cannot move this from state court to federal court. And they're now at the higher level court making the argument that the immunity decision last summer converted this state court prosecution into something that's sufficiently federal that a federal judge should now look at it and basically toss it out because some of the evidence, according to Trump's lawyers, is now protected by the Supreme Court's immunity decision and should not have been before the jury.
This is one of the first major tests of this landmark Supreme Court decision. What kind of precedent could this decision set?
Well, this really is a stretch, Diane, because remember the hush money payments, this was in the lead up to the election. This is not core activity that took place while Donald Trump was president.
However, and they are smashing them, not chipping at the edges, not issuing narrow rulings that leave room for escape, smashing them completely, permanently. And here is what makes this different from every other legal battle Trump has faced in his lifetime. The delay game is finished. The strategy of flooding the system with appeals, emergency motions, procedural chaos, pushing every consequence past the next election, past the next inauguration, into an endless horizon where accountability never quite arrives. That strategy worked for years. It just hit a wall it cannot climb. The New York appellate courts rejected it. The United States Supreme Court rejected it in a 5-2-4 ruling that included Trump's own appointees. The sentencing went forward. The conviction stands, and now federal judges are handing down rulings on executive power that do something far more dangerous for Trump than simply losing a case.
President Trump was convicted on those 34 counts. It's because President Trump and his legal team made these arguments going into that trial, during that trial, and coming out of that trial. It's what we heard from President Trump almost every day in the hallways of that Manhattan courthouse, where he would go to the cameras, as you're watching right now on some of those still pictures, and talk to the press who was waiting there for him every day. It's what his legal team made in front of the judge, that there should have been some kind of immunity in this case and that the judge should have recused himself. That is the grounds that this Trump legal team filing says is grounds for potentially overturning this criminal indictment that makes President Trump a felon. Now,
they are establishing constitutional guardrails that will outlast his presidency, outlast his lawyers, outlast every emergency appeal he can file. Today, we are walking through the two fronts where Trump's defenses have just suffered catastrophic structural failure: the hush money sentencing that every court refused to delay, and the executive order demolitions where multiple federal judges independently ruled that his claims of unlimited presidential authority over elections are not just wrong, but unconstitutional. When you see these two developments together, the picture becomes unmistakable. The architecture of impunity is gone. Let us start in Manhattan, because this is where the delay strategy went to die. May 2024, a jury convicts Donald Trump on 34 felony counts of falsifying business records. First former president in American history convicted of crimes by a jury of ordinary citizens. And from that moment, Trump's legal team launched an all-out assault on the sentencing process. Motion after motion, appeal after appeal, emergency request after emergency request, all designed to achieve one objective: push sentencing past the election, past the inauguration, into the fog of presidential immunity claims where consequences disappear. Here is what they argued: a president-elect cannot be burdened with a criminal sentencing. He has a country to run, a cabinet to staff, a transition to manage. The burden is too great, the irreparable harm too severe. The courts needed to step in and postpone everything until after he assumed office. A New York appellate justice looked at that argument and said, no, the normal appeals process exists for a reason. If there were errors at trial, address them on appeal like every other convicted defendant in America. That was the first crack. So Trump escalated to the Supreme Court of the United States. Emergency application. 9 justices, please intervene. Block the sentencing. And in a 5-4 decision, the highest court in the land denied him. 5-4 on a court with a 6-3 conservative supermajority. On a court where 3 justices were personally appointed by Donald Trump. Even with that composition, even with the immunity ruling that expanded presidential protections, there were not enough votes to delay a criminal sentencing.
And now, while he was sentenced right before the election to no criminal time served in prison, and it would have been complicated anyway, given that President Trump is currently in office, the label felon still applies to President Trump within the grounds of New York State. That's something that, as you know, obviously irritates him. At the same time, we know that this is just one prong of 2 that the Trump administration and Trump's legal team are trying to currently do to overturn this. The other read is asking a federal court to take this state court and pull it into that kind of vacuum over there to potentially overturn it on that grounds. They're hoping that one of these 2 potentially works.
All right, Jake Rosen reporting live. Thank you so much for that analysis.
And the reasoning matters. The majority said any alleged trial errors could be addressed through ordinary appellate channels, the same process available to every other defendant. Then they described the burden of the sentencing itself: a brief virtual hearing resulting in unconditional discharge, no jail, no probation, as relatively insubstantial even for a president-elect. Relatively insubstantial. The Supreme Court telling a man about to assume the most powerful office on earth that showing up for his felony sentencing is not a big enough deal to warrant special treatment. The sentencing happened. The conviction is permanent. He entered the presidency as a convicted felon, and no court in America would stop it. Now, here is the legal nuance that explains why immunity could not save him. The Supreme Court's immunity ruling in Trump versus United States created broad protections for official presidential acts, absolute immunity for core constitutional functions, presumptive immunity for other official conduct, but the ruling explicitly deliberately left private conduct completely unprotected. The hush money case was private conduct falsifying business records in a personal corporate capacity to conceal a payment during a campaign, nothing to do with presidential power. The court drew a bright line. Immunity protects official acts. It does not protect private crimes. The conviction survived every challenge because it was never within immunity's reach. Now, shift to the executive order front, because this is where the second pillar collapsed. Executive Order 248, sweeping election order attempting to impose documentary proof of citizenship requirements for voter registration. Restrict counting of timely postmarked mail ballots arriving after Election Day. Tie federal election funding to state compliance with Trump's preferred voting rules. The order was designed to concentrate election authority in the presidency like never before. Federal Judge John H. Chun issued a permanent injunction, not a temporary pause, a permanent block, and he did not stop at technical drafting problems. He rejected the entire constitutional theory underlying the order, ruled that Trump has no authority to impose new national election rules that override state law and disenfranchise voters, found the order violated separation of powers by attempting to concentrate election regulation in the presidency, a power the Constitution assigns primarily to states with a secondary role for Congress and essentially no role for a president acting alone. Then he described the order in language judges rarely use, called it a direct threat to democracy, wrote that his injunction was necessary to restore the proper balance of power among the branches as envisioned by the framers. Separate case, different judge, different court. Federal Judge Callie Kelly ruled that specific sections of the same executive order, the citizenship verification provisions, the federal funding conditions, were inconsistent with constitutional separation of powers and could not lawfully be implemented. Same constitutional reasoning, independent judicial analysis, two different judges examining the same order through separate proceedings, both concluding it violates the Constitution. That is not one judge's political bias. That is a structural constitutional finding about the inherent limits of executive authority. And structural findings do not get fixed by rewriting an executive order or issuing a new one with modified language. The theory itself is unconstitutional. Let us connect the dots because the simultaneous collapse on both fronts changes everything. The first takeaway is that the Supreme Court's refusal to delay sentencing established a governing principle for the rest of Trump's legal exposure. Presidential status does not confer unlimited delay privileges in criminal cases arising from private conduct. That principle was theoretically implicit in the immunity ruling. The sentencing fight made it operationally real. The highest court in the land allowed an actual sentencing of an actual president-elect to proceed on schedule while he was literally preparing to assume office. That precedent applies to every future criminal proceeding. Classified documents case if revived, state prosecutions after he leaves office, any future federal charges based on evidence Jack Smith preserved. Courts will not treat presidential status as grounds for indefinite postponement of consequences for private conduct. The sentencing proved that definitively. Second takeaway. The back-to-back rejections of Executive Order 115248 by two judges reaching identical conclusions independently have established a legal barrier against presidential control of elections that is as permanent as constitutional law allows. The courts did not find fixable drafting errors. They found the fundamental theory of presidential power underlying the order unconstitutional. Structural constitutional findings can only be overcome by constitutional amendment, requiring supermajorities in Congress and ratification by 3/4 of the states, or by future Supreme Court reversal abandoning separation of powers principles settled since the founding. Neither is plausible. The wall is permanent. Third takeaway, tying both fronts together. These rulings strip away the two foundational pillars of Trump's entire legal strategy. Delay is gone. Courts said sentence on schedule like every other defendant, and the Supreme Court agreed, calling the burden relatively insubstantial. Unlimited executive authority is gone. Multiple judges independently said presidential power has specific constitutional limits, and when those limits are exceeded, the judiciary will enforce them without hesitation. Without those pillars, the entire defensive architecture Trump spent years and millions constructing is fundamentally and irreparably compromised. Here is where we land. Donald Trump is governing as a convicted felon, first president in American history with a standing felony conviction courts at every level refused to delay or set aside. His most aggressive claims of executive authority over elections have been permanently blocked by federal judges who called them unconstitutional and a direct threat to democracy. His immunity from prosecution extends only to official acts, leaving his private conduct fully exposed to prosecution now in state courts and in the future in federal courts once he leaves office and the DOJ policy shield expires. The delay strategy that served him for years has been explicitly rejected by the Supreme Court in the most concrete terms imaginable. They let the sentencing happen. They called the burden relatively insubstantial. They treated him like any other convicted criminal defendant. The defenses are collapsing right now. Real cases, real rulings, real judges, including justices on the Supreme Court Trump himself appointed. The walls he spent years constructing to keep legal accountability at bay are coming down, one ruling at a time, one rejection rejected appeal at a time, one judicial finding at a time. And on the other side of those crumbling walls, waiting with the infinite patience the American legal system is famous for, is the evidence Jack Smith swore under oath meets the criminal conviction standard. The felony conviction courts refuse to delay the constitutional principles judges from both parties have carved into permanent legal precedent. And the fundamental promise of American justice that no person, regardless of wealth or power or political position, is above the law or beyond the reach of accountability. The path to that accountability is clearing. The defenses that blocked it are failing, and the only shield remaining between Donald Trump and the full force of the criminal justice system. The DOJ policy against prosecuting a sitting president has an expiration date that arrives with absolute certainty the moment he walks out of the Oval Office for the last time. The shield is temporary, the evidence is permanent, and the path is open. That is it for today. If this breakdown brought you clarity, hit that like button and subscribe, because we are tracking every development as it unfolds. Trust me, you do not want to miss what comes.